If you or somebody precious to you has been waiting, sometimes for months, sometimes for years, for a green card or a visa progression, then what I am about to reveal to you right now is something you simply cannot afford to overlook. Because this month, something genuinely consequential has transformed in the U.S. immigration system, and it touches hundreds of thousands of families throughout this nation and across the entire globe. So remain right here, because over the coming few minutes, I am going to guide you through the most substantial green card and visa processing transformations for April 2026, detail precisely what they represent for you, identify who can move forward right now, and hand you the concrete actions you need to execute today. This is US Updates Hub, and as always, we are here to guarantee you possess the knowledge you require, presented clearly, truthfully, and without the dread and bewilderment that so commonly accompanies this subject. Let us open with what is conceivably the single most remarkable transformation in this month's bulletin, and that is what has transpired in the F2A visa category. Now, if you are not acquainted with the phrase, let me clarify it plainly. The F2A category includes the spouses and unmarried children below the age of 21 of lawful permanent residence. Stated another way, green card holders, not U.S. citizens, but green card holders. And for the families of green card holders, this category has traditionally been one of the most distressing places to remain. There have been backlogs extending for years, with families residing apart, spouses divided, children maturing away from a parent, all because the system simply contained more applicants than obtainable visa numbers. But here is the headline. As of the April 2026 Visa Bulletin published by the U.S. Department of State, the F2A category has returned to current across all countries on the dates for filing chart. Now, when we state a category is current, what that conveys in everyday language is this. There is no delay. There is no priority date cutoff restricting you. Eligible spouses and children who are physically present in the United States can immediately submit their Form I-485, the application to register permanent residence or adjust status regardless of their priority date. That is an enormous, genuinely life-transforming advancement for thousands of families. And here is some supplementary context that renders this even more striking. In September 2023, nearly 380,000 approved Form I-130 petitions in the F2A category were resting in a queue awaiting a visa number to become obtainable. 2 years later, that figure had declined to 22,990, a 94% decrease according to USCIS data. Let that absorb for a moment, a 94% decrease in the waiting list. That is not a modest enhancement. That is a sweeping clearing of the queue. And the reason it holds such importance right now is that it has enabled current status achievable in this April bulletin. This has not transpired since 2022, and it may not endure. I want to be extremely candid with you here because this is vital. Visa bulletin dates can reverse backward, what immigration professionals call retrogression, and that can transpire with very minimal advance warning. The F2A category was current briefly in late 2022, then retrogressed for over 3 years. Families who overlooked that opening are only now obtaining another opportunity. So if you qualify, now is the occasion to move. Not next month, not after you deliberate about it for a few weeks. Now. And I will outline exactly what actions to execute shortly. But first, let us step back and grasp the wider landscape of what the April 2026 Visa Bulletin represents, because the encouraging developments reach well beyond just F2A. The Visa Bulletin, for those who are newer to this journey, is a monthly release from the U.S. Department of State. It is the government's authoritative reference to immigrant visa availability. It notifies green card applicants, both those within the United States who are adjusting their status and those overseas going through consular processing when they can advance forward. The Bulletin operates as the government's definitive reference for immigrant visa availability, defining the timeline for both family-sponsored and employment-based applicants. The Bulletin functions on two charts. The Final Action Dates chart discloses when a green card can actually be granted and delivered. The Dates for Filing chart discloses when you can turn in your documents in advance, even if your visa number has not yet been formally allocated. For April 2026, USCIS has verified that both family-sponsored and employment-based applicants should reference the Dates for Filing chart. This is actually meaningful in its own right because it indicates the more advantageous earlier dates apply, affording more applicants the capacity to enter the system sooner. Now, let us review what transpired across the family-based categories more comprehensively. The F1 category, adult children of U.S. citizens, progressed meaningfully by approximately 6 months across most countries, while the F2B and F3 categories also exhibited steady advancement. To place that in context for F1 applicants, a 6-month progression in a single month is substantial forward advancement. That indicates if your priority date was previously past the cutoff, it may now be within range. F2B, which includes unmarried sons and daughters aged 21 and older of green card holders, advanced from March 15, 2017 to August 8, 2017. F3, which includes married sons and daughters of U.S. citizens, advanced from July 22, 2012 to November 22, 2012. And F4, which includes siblings of U.S. citizens, advanced from March 1, 2009 to May 15, 2009. These categories still involve extended waits, and I want to recognize that truthfully, but advancement, even gradual advancement, indicates individuals are drawing closer. It indicates the system is not immobilized. On the employment-based side, the landscape is more layered. EB1 and EB2 remained largely static, though EB2 India progressed modestly. EB3 exhibited meaningful forward advancement for India and returned to current for most other nations. For skilled workers in the EB3 category, outside of the significantly backlogged nations like India and China, the dates for filing being current is an open gateway. If you are a professional with an approved I-140 petition in EB3 and you have been waiting to submit your I-485, this month may be the chance you have been searching for. And even for Indian and Chinese nationals in EB2 and EB3, any forward advancement is truly appreciated news after years of remarkably sluggish progress. Now, there is background behind why these dates have advanced forward so considerably, and I want to present it to you because grasping it assists you contemplate what might unfold next. Since October 2025, USCIS has continued to utilize filing dates to determine when applicants can submit Form I-485. The immigrant visa freeze impacting 75 countries could be connected to the dramatic forward acceleration in the March and April 2026 Visa Bulletins. In other words, when nationals from a substantial number of countries are unable to advance forward with consular processing, the visa numbers that would have been designated to them become obtainable for others. If nationals from nearly a third of the globe cannot advance forward with consular processing, a surplus of immigrant visas may exist. And because USCIS must estimate supply and demand into the future, a prolonged freeze indicates that the overall quantity of green cards obtainable remains controllable. This is a double-edged circumstance. It indicates encouraging developments for those who can move right now, but it also indicates the forward advancement may not persist forever. The State Department advises that forward advancement in 1 month does not ensure continued progress later in the fiscal year, and retrogression remains conceivable later in the year if demand exceeds obtainable visa numbers. So please regard this seriously. The opening is genuine, but openings can shut. Let me now guide you through the practical actions you need to execute if you believe this month's bulletin could relate to you. I want to maintain this approachable and straightforward, so let us handle it piece by piece. The very first thing you need to accomplish is determine your visa category. Are you the spouse or minor child of a green card holder? That would position you in the F2A category. Are you an adult unmarried child of a green card holder? That is F2B. Are you a married child of a U.S. citizen? That is F3. Are you a sibling of a U.S. citizen? That is F4. Are you an employment-based applicant, a highly skilled worker, an advanced degree holder, or someone in a specialized discipline? You would belong to the EB1, EB2, or EB3 categories. Identifying your category is the cornerstone of everything else. Once you determine your category, find your priority date. Your priority date is typically the date when your immigrant visa petition, your Form I-130 for family-based categories, or your Form I-140 for employment-based categories was initially submitted. You will locate this date on the receipt notice USCIS dispatched when your petition was submitted. If you are uncertain, examine your documents or reach out to whoever assisted you in filing. Next, navigate to the official Visa Bulletin on the U.S. Department of State's website at travel.state.gov. Locate your category and your country of birth in the April 2026 Visa Bulletin. Measure your priority date against the date displayed. If your priority date is earlier than the date in the chart, or if the chart indicates current, you may be qualified to submit. But here is an essential step that many individuals overlook. Before you submit anything, verify with USCIS that the dates for filing chart is authorized for your category in April. USCIS must independently authorize use of the dates for filing chart each month. That authorization is not automatic and must be verified before any submission is initiated. You can confirm this at uscis.gov Visa Bulletin Information page. This page is refreshed each month and it will verify which chart USCIS is receiving applications under. Do not bypass this step if you are in the F2A category and qualify to submit. Here is what a thorough adjustment of status package typically encompasses. You will require Form I-485, the application to register permanent residence or adjust status. You will require Form I-864, an affidavit of support from your sponsoring family member proving they satisfy the income thresholds. You will require supporting documents, including evidence of the sponsor's permanent resident status, evidence of your relationship, whether that is a marriage certificate or a birth certificate, passport copies, and proof that you have preserved lawful status in the United States. You will also want to seriously contemplate filing Form I-765, the application for employment authorization, and Form I-131, the application for travel documents, at the same time. Filing Form I-485 early can avert future complications around expiring underlying status, and filing simultaneously permits you to request advance parole or an employment authorization document which enables you to work or travel internationally while your green card petition remains pending. These simultaneous filings can be a tremendous breakthrough for many families. I also want to address briefly those of you who are in employment-based categories and have been tracking the EB3 advancement this month. If your priority date is now within range, and especially if it has turned current on the dates for filing chart, this is a perfect time to have a discussion with an immigration lawyer about submitting your I-485 if you have not already. And for those with pending I-140 petitions who are weighing premium processing, I do want to present a noteworthy development on that front as well. As of March 1st, 2026, USCIS implemented revised premium processing fees. The premium processing fee for Form I-129 non-immigrant worker petitions requesting classifications such as E3, H-1B, L-1, O-1, and TN increased to $2,805. The premium processing fee for Form I-140 immigrant petitions for employment-based categories also increased to $2,805. Additionally, the premium processing fee for certain Form I-539 and Form I-765 applications also increased to $2,155 and $1,890, respectively. These increases are part of a biennial inflation-based adjustment sanctioned under federal law. The purpose is to maintain the real value of premium processing services and sustain USCIS operational capacity. Now, I acknowledge that elevated fees are never pleasant news, but here is the crucial perspective. Premium processing remains obtainable for many essential categories, and it can still be a critical instrument for time-sensitive circumstances. Most employment-based petitions are assured a response, either a decision or a request for additional evidence within 15 business days when premium processing is requested. If you are encountering a lapse in work authorization, a cap-gap predicament, or a business essential deadline, premium processing may still merit the expenditure. Just confirm any Form I-907, the request for premium processing service is postmarked with the revised fee because requests submitted with outdated fees after March 1st will be declined and returned, resulting in setbacks. Now, I want to take a moment to be forthright with you about something because that is what this channel stands for. The wider landscape of USCIS processing times remains demanding in 2026. The duration it requires USCIS to process most petitions remains prolonged, with some cases needing several months or even years to arrive at a determination. Family and employment petitions encounter extended waits, with I-130s for green card holders needing up to 35 months and perm labor certifications contributing over 16 months to green card timelines. This is genuine and it is exasperating, and I do not want to understate it. The encouraging developments in the Visa Bulletin this month do not eliminate the underlying backlog obstacles. What they do is unlock particular filing openings that could safeguard your place in line, secure you work authorization sooner, and position you for a green card grant when your final action date turns current. So please harness this moment wisely. Contemplate it this way: filing your I-485 now. When the dates for filing chart permits, it is like claiming your place in a line even before the counter opens. You are shielding yourself. You are anchoring your position. With cutoff dates shifting so rapidly, anchoring your place in the adjudication line could produce a meaningful difference in how swiftly your timeline to a green card advances forward. I also want to briefly speak to those of you who may be outside the United States going through consular processing. The Visa Bulletin changes are applicable to you as well, particularly if your priority date has turned current on the final action dates chart. Your route is through the National Visa Center and ultimately a consular interview at a U.S. embassy or consulate in your nation. Track your NVC case status, verify your documents are thorough and current, and follow any directives from the embassy attentively. If you have a scheduled appointment or are awaiting one, remain in close communication with your lawyer or accredited representative. Here is something else I want to urge all of you to accomplish, regardless of where you stand in the journey. Maintain your documents organized and current. This means knowing where your priority date receipt notices are. It means verifying your passport will not lapse in the middle of your case. It means confirming your financial sponsor has present income documentation prepared. It means reporting any address modifications with USCIS promptly through your USCIS online account or by submitting an AR-11 form. These minor administrative actions are the things that prevent cases from becoming stalled for preventable reasons. And if you have a child nearing the age of 21 who is included in your petition, please consult with a qualified immigration lawyer at the earliest opportunity. There are legal safeguards under the Child Status Protection Act that may assist in preserving eligibility, but timing is paramount. and professional counsel is indispensable. Before I wrap up, I want to present a brief but significant reminder that this content is for informational purposes only. It does not represent legal advice, and every immigration circumstance is distinct. The changes I have presented today are sourced from the official April 2026 Visa Bulletin from the U.S. Department of State, guidance from U.S. Citizenship and Immigration Services, and reporting from trustworthy sources, but immigration policy can shift at any moment without warning, and what holds true today may alter by next month. Please confirm all information through official channels: USCIS at uscis.gov, the Department of State's Visa Bulletin at travel.state.gov, and the Department of Homeland Security at dhs.gov. And for anything particular to your individual circumstance, please seek out a qualified immigration lawyer or accredited representative who can examine the specifics of your case. On-screen note: policy changes can transpire at any time. Information in this video is current as of April 11th, 2026. Always confirm with official sources before filing. This is why US Updates Hub exists, to be the resource you can depend on to cut through the intricacy, deliver you the changes that count, and assist you comprehend what they represent for your life. Whether you are a recent arrival navigating the system for the first time, a senior who has resided here for decades and is finally pursuing citizenship or residency, or a working professional awaiting that employment-based green card to advance forward, you deserve straightforward, truthful information, and that is precisely what we are devoted to providing you. If this video assisted you today, please take a second to give it a like and forward it to someone in your community who could gain from learning about these April 2026 changes. Your shares produce an enormous impact in assisting families who require this information actually locate it. Subscribe to US Updates Hub so you never miss a monthly Visa Bulletin analysis, a USCIS policy change, or a development that could influence your immigration path. Review the description beneath this video for links to official resources, including the April 2026 Visa Bulletin, USCIS processing time details, and guidance on where to locate qualified legal assistance. You have worked tirelessly to reach where you are. You have been patient, and for many of you, this April 2026 bulletin is the moment you have been anticipating. Do not allow it slip past you. Take action. Confirm your eligibility through official channels. Seek a professional if you have any uncertainty, and keep advancing forward. We are championing you every step of the way.